Hello, Dan Marr here from Hamlin Kerrigan in Nashua, New Hampshire. I'm going to be talking today in this vlog about firing an employee or terminating the employment relationship. It might be because of a layoff, it might be because of performance. We're going to be talking about that in this vlog today. I'm an attorney that's been here at Hamlin Kerrigan for 35 years. Before that, I was 1 year with a clerkship with the Superior Court, so I've dealt with litigation both in New Hampshire and state and federal courts, both in New Hampshire and in Massachusetts. But today we're focusing in on New Hampshire, and I've represented a lot of employers in regards to the employment process, including the termination of the employment process. So if you're in a situation where you're considering terminating the employment of an employee, consider, of course, what you're really doing it for, and make sure that you have the basis for doing so. Just relying on your supervisors directly without doing some of your own investigation could do a disservice to the company. You obviously need to make sure that you have the right basis for something. I have had cases before that I've had to defend where the supervisors had a discriminatory animus towards women. They didn't like working with women or some other protected class, and that tainted their information that they gave up to the upper management. The upper management makes decisions in regards to that. There's something called the cat's paw theory, where the company's still liable even though the person that's making the decision didn't have discriminatory animus, because somewhere in the process the information was tainted because of that. So you want to investigate, you want to make sure you understand what's going on, and you want to treat people fairly, and you want to make sure that you know what the basis is for the termination and that it sticks. Also, when you're dealing with, if there's a claim later, we'll talk about this in another vlog, there's the Human Rights Commission or the EEOC, and then maybe ultimately a jury that would make a determination of whether you would treat people fairly. In that process, everyone that's thinking, they're human beings, they're thinking, how would I like to be treated? And giving somebody an opportunity to know what they did wrong and correcting it if there's something that is correctable makes sense. So if they have a performance issue, that they're not doing things the right way, documenting it and telling them what's going on is different. Now, of course, if they're embezzling or they sexually harass somebody intentionally, they grab somebody or said something really, really offensive, of course you don't have to wait and give them an opportunity to fix that, because they should be fired, and they should be fired quickly, and that's good for the morale of the company and not putting up with that. But still, you should talk. I generally like my clients to talk to me first to make sure we get all our ducks in a row to do it the right way, and make sure that we have the justification for the firing. But if you give them the opportunity to correct themselves, and they come back and they explain the circumstances, maybe it might be a situation where you find out that they have a physical or mental disability that they need some accommodation. Depending on the size of the company, your attorney can tell you about this. There's something called a reasonable accommodation, and reasonable is also determined on the size of the company. Maybe a mentoring might help. And I can also tell you from years of experience in dealing with this, when you do have somebody that's just not carrying their weight and they become a success story because you have somebody else that helps them because you ask them to train them and make them a better, they have an epiphany that they have to change their work ethic and the like, and it is a wonderful experience for the team. And it's not a family, you don't fire family, but you fire team members when they don't pull their own weight, but they are all expected to help and try to pull their own weight, and it's really good morale booster for the entire team, meaning that everyone's feeling like they're treated fairly, but there's accountability, and that can be a real win-win situation. So those things make a lot of sense in regards to this. I think of diligence, dignity, and fairness. So fairness, obviously, we talked about before, but diligence and dignity, diligence is making sure that you've checked also everything to make sure that what you're dealing with is truly what the reason is for the being fired. It's not some type of discriminatory animus out there. And the fairness, you don't have to go and fire somebody in front of everyone else. If you think that that's the type of boss you want to be, you're wrong. It's horrible for morale. You want to be in a situation where everyone's thinking, yeah, this boss of mine is fair. And a good firing, frankly, can be good for morale if the person's not doing their job and they're being treated fairly. But all of those things make it easier for me later on if there's a discrimination case, and maybe even avoiding a discrimination case or other type of wrongful termination claim if I'm there to defend those cases on behalf of the company. So if you have questions in regards to this, you can contact me, Dan Marr, at 603-883-5501, or you can check out our website at hamker.com. That's hamker.com. Thank you. I look forward to working with you if the opportunity arises.